Modifying or terminating no contact orders in Indiana. In Indiana, if you are charged with a criminal offense that involves another person, normally a civilian, then the state of Indiana more than likely is going to ask that a no contact order be put in place while the case is pending. Those are what are called pretrial no contact orders. Additionally, if you take a plea agreement that includes a no contact order, or go to trial and are convicted, there can be a post-conviction no contact order as well. Now, these no contact orders can prohibit you from having any sort of contact with the person that's listed in that no contact order. That's face-to-face contact, but also any text messages, phone calls, letters, or even having a family member or friend reach out on your behalf. Any of that is a violation of that no contact order. Whether it's pretrial or post-conviction, any violation can result in a new crime called invasion of privacy. Now, a question we get at Marc Lopez Law Firm a lot is, can a no contact order be modified or terminated? And the answer is yes. In order to have the no contact order terminated or modified, the person that is being protected by that no contact order typically needs to do a few things. First, they need to let the prosecutor know of their desire to either modify or terminate that no contact order. And additionally, more likely than not, that person's going to need to show up to court and tell the judge that they want the no contact order modified or terminated, and the judge is going to ask them why they want that. Most of the times, no contact orders are issued without the other person being asked whether or not they want that no contact order. Now, that can tear families apart. One bad night can lead to the police coming there, and then before you know it, you're charged with a crime, but there's also no contact orders issued against your spouse and even your children potentially. Now, that can cause a big strain in your life, but as long as the other party is comfortable with that no contact order being lifted or modified in some situations, then typically a court will grant the termination of that no contact order, so long as the person that's protecting doesn't have any safety concerns or feels threatened around you. Now, in some situations, the party that's being protected by the no contact order may not want it terminated entirely, but does want it modified. And a lot of times we see this when there's cases involving families. Now, it might be the situation where the alleged victim doesn't want to have any contact in person with the person that is alleged to commit a crime, but they want to be able to talk on the phone in order to facilitate child care. In that situation, that person can let the prosecutor know, or the judge as well, that they don't want the no contact order terminated, but they do want it modified in a way that the family can still be able to function while the case is pending. If you're facing criminal charges and have a no contact order against you and have questions about getting it modified or lifted, please give us at the Marc Lopez Law Firm a phone call, 317-632-3642, and always remember, plead the fifth.